Hey guys, welcome back to my channel. I am your friend Arman. So today in this video we're gonna learn general defense or tortious liability. So yesterday we have learned about mental element in tortious liability, malice and all that. So today we will learn general defense of tortious liability. Okay. So general defense under tortious liability. Okay. So guys, let's understand what does the general defense means. Okay. So it means like if you commit a tort, okay, and in what are the situations when you can evade or you can like escape from the liability arising out of the tort. Okay. For example, okay, suppose this is Mr. A and this is Mr. B. Okay, and A has committed a tort against B. So he is a defendant and this is a plaintiff. Okay, so there may be certain situations when like when A can escape from the liability arising out of the tort that he has committed against the B. Okay, so what are those situations? So that situations or the what are the right or say defense he can take against the plaintiff or against such tort that he has committed. Okay, so that we are going to discuss today. So guys, the number one general defense of tortious liability is very essential. Okay, in most of the exams question generally comes from this defense only, that is volenti non-fit injuria. So volenti non-fit injuria. Okay, so guys, what does volenti non-fit injuria means? Okay, volenti non-fit injuria means consent of the plaintiff. So it means consent of the plaintiff. Okay, suppose there is a two person. Okay, A and this is A and B. Okay, so A is a defendant here and B is a plaintiff. So B is a plaintiff. Okay, so A has committed a tort against the B. Okay, but what happened? But for the tort or whatever the wrong is being suffered by B, it was caused voluntarily because B has already consented. Okay, B has given his consent to suffer such loss or harm which is being inflicted upon B by A. Okay, so that's what it means. Okay, that means like if a person, if I give consent that okay fine, if certain harms inflicted upon me, okay, I will not say anything to you. So in that case, I will, even if I suffer any loss out of that consent, I will have no right to seek for the remedy. Okay, so that's what it means. Okay, when the plaintiff consent for the infliction of harm or loss to be caused upon himself. So in such situation, what happens? In such situation, the plaintiff will have no right to seek for remedy or seek for compensation from the defendant. Okay, so that's what the volenti non-fit injuria means. Okay, let's take the example. And this kind of questions generally comes in the exam. Suppose so this is me. Okay, suppose this is me. Okay, this is me. So this is me. Okay, and I went to watch a cricket match. Okay, cricket match. So I went to watch a cricket match. Okay, so what happened during the cricket match? Like the players were playing. Okay, I was the spectator of the match. Okay, so what happened? The batsman hit the ball. Okay, hit the ball, and that ball come and hit my head. Okay, that ball comes up to my head, and I got a few injury out of that. So in such situation, I cannot file a suit against the cricketer because I have given the consent to suffer all the possible injuries. Okay, all the possible injuries which can be inflicted to any person. Okay, and this is So that is why I will have no right to claim for damages from the defendant. Okay, that means the batsman. So because I have given the consent, and that is, and in that case, the defendant will have the what defense? That is what defense? That is consent of the plaintiff or say voluntary non-fit injuria against me. Okay, if I say that no, I have not given the consent and all that, if I plead like that, so in such certain situation, the defendant will have the defense to protect himself from the liability. That is voluntary non-fit injuria or say consent of the plaintiff. Okay, let's take another example. Let's take this another example where like suppose there are 11 so there are football match. Okay, there is a football match. Okay, so during the playground, okay, there are many players and playing the football. Okay, so it is necessary to certain it is not necessary that I mean to say a general injury is like anticipated. Okay, a certain I might get certain nominal injuries in every situation while playing in the football. I might get hit by someone, or I might hit someone else. So if I'm doing if I'm playing football, so normal injuries are expected. Okay, but if the player intentionally and causes the violence against the another player. Okay, another player with malice. Okay, with malice. I think you remember what is malice. Malice is an evil motive. Okay, yes, yesterday we have discussed about it. So the player caused the violence against another player with malice. Okay, so in certain situation, the defendant will not have the defense of voluntary non-fit injuria, because this is not happening out of the general course of the match. Okay, because since he is voluntarily causing a harm to the another player with the intention of with the evil intention, so that's why, so he will not be entitled for the defense of voluntary non-fit injuria. But in the normal course of the game, normal injuries suffered by the players is always covered under the defense. Okay, that is voluntary non-fit injuria. All right, I think it is clear to you now what is voluntary non-fit injuria means. Okay, so this kind of questions came. Okay, they will give you example and what kind of defense comes under it. So this kind of question generally comes. Okay, so there is a very important case law, that is Hall versus Brooklyn's Auto Racing Company. Okay, Hall versus Brooklyn Auto Racing Company. So in this case, what happened? The plaintiff went to watch auto racing. Okay, auto racing by paying certain amount of ticket fees and all that. He went to watch the auto racing. Okay, so what happened during the race? Two cars. Okay, so two cars. What happened? So two cars collided. Okay, so two car collided. So two car collided. What happened? And one of the car flew. Okay, flew, and what happened? That car fell upon the plaintiff. Okay, fell upon the plaintiff, and thereby plaintiff suffered the injury. Okay, plaintiff suffered the injury. Then plaintiff filed the suit against the defendant. Okay, plaintiff filed the suit against the defendant, but since the plaintiff has given the consent, and this kind of injuries, whatever was being suffered by the plaintiff, it was not out of the malice. Okay, it was not. There is no existence of malice, and since he has given the consent to watch the moment he purchased the ticket of the match, he has given the consent, whatever the expected or unexpected injury, which can be anticipated by the general human. So such kind of injuries comes under the general defense, that is voluntary non-fit injuria. So that's why the plaintiff was not allowed compensation, and the defendant was allowed the voluntary non-fit injuria. Okay, because if defendant has the has got the right to defend himself with this general defense. Okay, that is voluntary non-fit injuria. Okay, so I hope it is clear to you now that what is voluntary non-fit injuria. Now there is a dimension of this voluntary non-fit injuria. It is a very broad topic, so we have to use after and repeat it one by one. Okay. So again, another case, and this is also a very important case. Okay, this is the Padmavati case. It is Indian case. Padmavati versus Dukkanayaka. Padmavati Dukkanayaka. It is 1975. So in this case, what happened? The Padmavati took the lift. Okay, took the lift from Dukkanayaka, who was a defendant. He has a car. Okay, so he took the lift and he boarded the car. Boarded on the car. What happened after going somewhere? The car collapsed. Okay, the car got into the accident and thereby the plaintiff suffered the injury. And then plaintiff, the Padmavati filed a suit against the defendant that I have suffered injury and all that because of the driver. Driver was not capable enough for driving and all that. She filed a suit against the defendant. But since he has consented and the catching under accident is expected thing. Okay, it is anticipated. Everyone can anticipate that like this kind of things can happen generally. Okay, so that's why what happened. She was denied of compensation, and the Dukkanayaka was allowed to take the defense of voluntary non-fit injuria. Okay. I'm trying to make it as fast as possible, and many of you have complained like saying that my videos are taking a very lengthy time and very lengthy videos. So I request, and in the description box I will mention that from what minute you will get what. Okay, I'll mention the description box. And but before I begin discusses more further about it, I'll tell you that you can follow me on Instagram. If you have any questions, you can directly talk to me in the Instagram. So I have given my Instagram handle in my description box. Okay, so do check it out and follow me. All right. So what is the main essentials to use this voluntary non-fit injuria defense? Okay. So the main essential requirement for using voluntary non-fit injuria is that the consent. Okay, the consent of the plaintiff. Plaintiff should be free consent. Okay, the consent of the plaintiff should be free consent. Okay, it should not be obtained by fraud or misrepresentation. Okay, so consent should be always free consent. All right, and so the consent should not be consent should be free consent always. Okay, so there was this case. The case law name is Lakshmi Ranjan versus Malhar Hospital Limited. But before I begin this case, I want to tell you one thing. Okay, so in order to under the essentials, one more thing is to be needed. That is, the defendant should not be should not be negligent. Okay, defendant should not be negligent. Okay. The consent should be free and the defendant should not be negligent in his work. Okay, if the plaintiff suffered the injury because of the defendant's negligence, so in that case the defendant will not be entitled for this defense of, that is, voluntary non-fit injury. Okay, so in the case of Lakshmi Ranjan versus Malhar Hospital Limited, in this case what happened? The plaintiff, noticed a painful lump on her breast. Okay, on her breast. So in this case, the plaintiff noticed a very painful lump on her breast, and which has no connection with her uterus. It has no connection with her uterus. So what happened? So during the surgery, the doctor removed her uterus. Okay, negligently. So it was held that the plaintiff, though the plaintiff given his consent for the surgery, but her surgery was only for the lump on her breast. Okay, it was not for the uterus. So since the doctor acted negligently, so that's why the plaintiff, the respondent or the defendant, who is a doctor, was held liable for the injury suffered by the plaintiff. Okay. So now we will discuss the exception of the voluntary non-fit injuria. Okay. So in what are the cases, what are the situations when the voluntary non-fit injuria you cannot apply? Okay. So we will see that. So number one is that rescue case. Okay. Rescue cases. It is an exception. Okay. Exception or say limitation. Okay. So rescue cases. So in rescue cases, though there is a consent from the plaintiff side for the injury, but the defendant will not be allowed to take the defense of voluntary non-fit injury. Let me give you an example so that it will be easy for you to understand. Okay. Suppose there is a person. Okay. There is a person, Mr. A, and there is a Mr. B, and there is a C also. Okay, Mr. C. Okay, what happened? So in this case, A is a rescuer. Okay, and B who is about to die. Okay, B is about to die by sinking. Okay, by sinking in the river, by drowning. Sorry, not sinking, drowning. By drowning. Okay, by drowning in the river. So drowning in the river. Okay. And B was about to die. B was supposed to die because of the fault of the C. Okay. Okay, because of the fault of the C. B pushed him to the river and he was about to die. So in that case, what happened? A jumped into the water and saved his life. Okay, saved his life. He took the B out of the water, and thereby A suffered a multiple injury. Okay, so in certain situation, okay, in that case, A has the right to sue C for the injury sustained by him. Okay, and in that case, C is not allowed to take the defense of voluntary non-fit injury. He cannot say that I did not ask him. Okay, he has done it voluntarily. So there was a voluntary service from his side. So he will not. I will not compensate him. So C cannot say to B A that I will not compensate. Okay, so that's what it means. That is rescue cases. Another example I'll tell you here. There is a case law. That case law is very important. Remember that. It's Hines. H-E-Y-N-E-S. Hines versus Hardwood. Okay. So it's in this case. So in this case, what happened? A servant. Okay. Servant who was a driver. Servant who was a driver of a horse, okay, of a horse car, okay. So what happened? He left the horse cars, and in middle of the road. So he left the horse in the middle of the road unattended, okay. Unattended. There was no one to look after the horse during that time, okay. So he left the horse in the middle of the road unattended. So what happened? There was a pedestrian boy who pelted a stone. So stone pelted the horse, and thereby what happens? The horse bolted, okay. B-O-L-T-E-D, okay. Remember this words are very important. So the horse bolted because of the stone which is being pelted over the horse, and thereby horse started running, and thereby causes a apprehension to the woman. Apprehension to the woman and her two children, okay, and her two children. Okay, so it has the horse caused the danger to the woman and two children. Okay, so in this case, what happened? Another policeman, okay, a police constable, run there, and he somehow controlled the horse and prevented the accident which supposed to be happened to the woman and two children of her. So the constable managed to settle down the horse, but while settling the horse, what happened? The constable suffered multiple injuries, okay. So thereafter he filed a suit against the defendant for the compensation since he has suffered the multiple injuries. So in order to make it good, so he filed a suit against the defendant, and in that case the defendant said that no, I did not ask you, okay, and whatever the injury suffered by you, it is voluntarily, I haven't asked you. So in that case, the court held that the defendant is not liable to get the defense of voluntary non-fit injuria, okay, and the plaintiff was given a compensation. All right. So this is an exception of rescue case, okay, exceptions where the voluntary non-fit injuria cannot apply, even if you have consented to that. Even if you have given the consent, but voluntary non-fit injuria cannot be applied by the defendant. Okay. So another situation that is illegal consent. So illegal consent. Suppose if I have given so in this case an illegal act and a consent to do an illegal act. So in that case, you cannot use voluntary non-fit injury. Say for example, a fighting bare hand. Okay, fighting bare hand. So fighting with bare hand. Okay, so I am fighting with another person bare hand, and that will obviously create a lot of injury to me or to him as well. Okay, so in certain situations you cannot say that it was if I suffered injury and I filed a suit against that person, the person cannot tell me that no, there was a consent from your side to fight with bare hand. Okay, we cannot say that. Okay, same because the act is illegal. Okay, so that's what it is saying. So a consent doesn't make the illegal act legal. That's what it means. Okay. I hope it is clear to you now. So now another exception, that is negligence, that I have already discussed. That is negligence. So negligence is what? So if the defendant is negligent. If the defendant is negligent, so there is a negligence. So though the consent is given by the plaintiff in order for the risk, the plaintiff has given the consent, but there was a negligence on the part of the defendant, and due to the negligence of the defendant, plaintiff suffered the injury. So in that case, the defendant cannot say that the plaintiff has consented for the injury, so I will not be liable for the compensation. no. The court will say no, and court will not allow him to take the benefit of voluntary non-fit injuria, and he will be held responsible. That means the defendant will be held responsible for the wrong suffered by the plaintiff. Okay. So that's what it means. Okay. So this is all about the voluntary non-fit injuria. Okay. So we have covered the first general defense of tortious liability. Now we will move ahead with the another definition of another general defense of tortious liability. So what is that? Okay. So let's look at it. So another is the plaintiff, the wrongdoer. Okay. Number 2 is plaintiff, the wrongdoer. Plaintiff, the wrongdoer. So if we see the plain meaning of the sentence, that plaintiff, the wrongdoer, a plaintiff who himself in the fault, so he will not be allowed. Okay, for the defense. Okay, so that's what it means. Okay, suppose I'll tell you. Okay. So the bookish language is that from an immoral cause, from an immoral cause, no action lies. So from an immoral cause, no action lies. Okay, this is what it means. Okay, if you are in the wrong position, you will not have the right to action. Okay, that's what it means. Okay, the plaintiff, the wrongdoer. If the plaintiff himself does the wrong and his wrongful activity resulted the harm to himself only, so in certain situations the plaintiff will not have the right for compensation or for action. Okay, so for example, there is a wall. Okay, there is a wall. This is a wall. Okay, and there is nails. Like kept in order to prevent the person from the unauthorized trespass. Okay, there was a lot of nails were put it in the wall, on the wall. So I have seen that. Okay, I have seen that there is a nail over the wall, and without the consent, without the knowledge of the person. Okay, I trespass. Okay, I trespass to the land of another person. So during the trespass, I got injured because of those nails. Okay. So in that case, what will happen? I am the wrongdoer here because without the authority of the defendant, I trespassed to his land, and during the trespass I suffered the injury. So in that case, if I file a suit against the defendant, that is the owner of the land, what the court will say? The plaintiff is the wrongdoer. The defendant has the defense of what? Plaintiff, the wrongdoer. Plaintiff caused the damage to himself only, so that's why he will be not responsible. Okay, so this is the meaning. Okay, but there is a situation. Okay, but if it is supposed, okay, if you are laying nails or say okay, there's a very important case law which in this case will make it very clear about this topic. That is Bird versus Holbrook. So Bird versus Holbrook. Okay, in this case, what the court has said. Okay. So in this case, what happens? The defendant lays a spring gun. Okay, lays a spring gun around his boundary. Lays a spring gun around his boundary. Okay. So there is a spring gun. And what happened? And he did not even give a notice about the spring gun thing. Okay, there is no notice about it. So there was a trespasser who during the he was about to do the trespass to the land of the owner. So owner. So during the trespass, the spring gun caused the injury to the plaintiff. Okay. So in this case, what happened? The plaintiff was allowed, though he was in the wrong position. He came to trespass his land, but during the trespass he suffered the injury, and thereby whereby he was allowed for the compensation by the defendant because the act of the defendant is not legal, because he never posted any sign or signboard for the same. Okay, for like there is a lay that he has laid down spring gun over his boundary. He didn't say it anywhere. So during the trespass, he got into the he suffered the injury. Okay, so that's why in this case the court said that a reasonable notice should be there. Court said the reasonable notice should be there where the people can understand, and laying down a spring gun or say running electricity wire, laying electricity wire and all that, this kind of works. If a person does, then even the plaintiff is in the wrong position, if plaintiff is the wrongdoer, still he will have the defendant will have no defense under the plaintiff, the wrongdoer defense. Okay, so that's what it means. I hope it is clear to you now. So now this topic is really small. You can understand it easily. I hope you have understood. Still, if you haven't, then you can ask me on Instagram or you can write on the description box. Okay. So now another general defense, that is inevitable accident. Okay. Number 3. Inevitable accident. So inevitable accident. So accident is what? Accident is always an uncertain act. Okay, that you cannot anticipate. Okay, so it is an unfortunate and uncertain act. Okay, so inevitable means what? Inevitable means an accident which you cannot by any means restrain from happening. Okay, that's what it means, inevitable. By taking all the reasonable means, you cannot prevent the happening. So that's what it means. So in the case of Stanley versus Powell, Stanley versus Powell, in this case 1891. So in this case what happened? What happened? Yeah, there were two persons. Okay, there were two person. Okay, there was two person, and they were a shooter. Okay, they were a shooter, and they went to the jungle for shooting a peasant. Okay, shooting a peasant, they went to the jungle. Okay, and while one person shooted. Okay, shooted on peasant. Okay, so peasant shooted the peasant. What happened? The bullet. Okay, the bullet. So the bullet, glanced over the oak tree. Okay, the bullet was glanced, glanced on oak tree. Oak tree. Okay, suppose he is firing from here to the peasant. Okay, this is a peasant, just suppose. But instead of going there, what happened? The peasant, ran away from here before the bullet reaches here. Okay, and what happened? The bullet, touched the oak tree. Okay, touched the oak tree, and the moment the bullet touched here, okay, the bullet glanced. Okay, glanced and hurt the plaintiff. Okay, hurt the plaintiff. Okay, so here in this case, what happened? The plaintiff filed a suit against the defendant that he has caused me harm. Okay, but what happened? What the court said that this is an inevitable accident because by any means, by all the precautions, because he is a professional shooter and he did it. Okay, with all the precautions taken, he did not pointed his gun to the plaintiff. Okay, he did not pointed his gun towards the plaintiff. So since he pointed towards the peasant only, so since the peasant ran away from there and the bullet touched the oak tree and it glanced off to the plaintiff, glanced and hurt the plaintiff. Okay, so that's why it's an inevitable accident. Okay, so it was like that. I hope it is clear to you now. It is very small case, okay? And very small thing that you can easily remember in the type of your own language also. It is an inevitable accident where by any means, or say a common man, okay, just say a common man would have done. Like under the inevitable accident, what the court presumed and what happens if the common man would have done the same. So, if there is a proper precautions taken by the person or the defendant, and even after such precautions, the accident happened. So such accident is called inevitable accident. Okay. So in that case, the defendant will have the right to defend himself under the inevitable accident. So inevitable accident is a general defense of tortious liability number 3. Okay. Now another general defense, that is act of God. Okay. Act of God, or say Wiesleisung. Not Wiesleisung, okay. So act of the God. So act of the God and the inevitable accident are the same thing, okay. But only the difference is that in the act of the God there is no intervention of the humans. Okay, it is the completely act of the God. So what kind of what it could be? It could be natural calamities, which is exceptional. Okay, it should be exceptional. It doesn't mean that just mere rainfall and all that. It doesn't cover on that thing. Okay, it should be exceptional natural calamities like volcanic eruption. It could be volcanic eruption and say famine, drought, many more. Okay, a tsunami and all that. So this could be anything. Okay, so natural calamities. So because of the act of the God, if something wrong is happened and which caused the which caused the harm to the plaintiff, then in that case the defendant will have the right to claim for the general defense, that is act of the God, in order to protect himself from the liability arising from that tort. Okay, so let's take the example here. Case law. There is a very landmark case law in this regard. That is Nicholas versus Marsden. Okay? Nicholas versus Marsden. So Nicholas versus Marsden. So in this case, what happened? Okay. So in this case, the defendant constructed a artificial lake. Artificial lake on his land. Okay, lake on his land by damming waterfalls. Okay, so by damming the waterfalls, he constructed an artificial lake in his land. Okay, the plaintiff, defendant, and it is stated that there was a torrential rainfall, and which has never happened in the human memory. This was one of the exceptional rainfall. Okay, and that rainfall, when the rainfall, the torrential rainfall, what happened? So all his dam and reservoir, also his artificial lake was fled away. Okay, broke down. His waterfall broke down. His artificial lake broke down, and what happened? All the water was contained in the lake. That flowed to the plaintiff's land. Okay, plaintiff's land. Okay, so So plaintiff's land, okay, so flowed towards the plaintiff land, and there was, the quantity of the water was so high, heavy, that it flowed away. It flowed away the four bridge. So 4 bridges of the defendant, okay, sorry, plaintiff, 4 bridges of the plaintiff, okay. So 4 bridges of the plaintiff were, rushed away by the water, okay. So in that situation, what happened? The plaintiff filed a suit against the defendant that because of the artificial lake constructed by him by damming the 4 dams, and when the water, water was excessive water from his artificial lake, fled away all his 4 bridges that is being constructed by the plaintiff. But the court said that, and the defendant's contention was that it is the act of the God. Defendant says it is the act of the God, because the rainfall, the quantity of the rainfall is so high, it is not ever been anticipated by any individual so far. So that's why the defendant was allowed to take the defense of act of the God. Okay, so I hope it is clear to you now. There is another case on this regard. After that case, it will be very easy for you to understand it more. So that is the case of the Madhya case. The case of Talulal versus Hemchand. So it is the case of 1958. So there was a rainfall, okay. There was a rainfall of 2.66 inch, okay. There was a rainfall of 2.66 inch, and it was a rainy season, okay. Rainy season. So it was a rainy season, and during that rain, what happened? A building collapsed. The defendant's building collapsed, okay. Defendant buildings collapsed, okay. What happened? That during the collapse of the building, plaintiff's 2 children died. 2 children died. Then what happened? The plaintiff filed a suit against the defendant for the recovery of the damages. And the contention of the defendant was that it was the act of the defendant, as an act of the God, so I will not be responsible. Then what the Madhya Pradesh High Court has done, that Madhya Pradesh High Court said that 2.66 inch rain in the rainy season, it is a normal thing. It is like it used to happen commonly. So that's why he was held responsible for the collapse, for the injury suffered by the plaintiff. Okay, so now I think it is clear to you. So now we will move ahead with another general defense, private defense. So private defense. Okay. So what is private defense? So for the private defense, like for my personal body or the body of another person or the property, in order to protect my body or the body of another person or the property, so I will have the right to use the reasonable force against the wrongdoer. Okay. Suppose if someone is coming with a bhala to kill me, then I can protect him. I can protect myself by throwing a stone and all that thing I can do. Okay, so that whatever the act done by me, and with that act, if the defendant suffers certain injuries, so in certain situations I can say that no, it was out of it was for the private defense. Okay, it was for my protection. So I can say that. Alright. So that is a private defense. It's a very simple concept. There is no there is nothing to read more. So there was so only one thing. The requirement is that Requirement in order to constitute private defense as a defense, that there should be a reasonable force. Okay, reasonable force. Reasonable force should be applied. So here it does not mean that like suppose if someone is coming to hit me with a stick, okay, with a stick, and out of that apprehension I took the pistol and shot that person. It is not a reasonable force. Okay, so in that situation I will be held responsible. Okay, but if he is coming with the stick to beat me, so I can also use a stick or I can do anything. Okay, but I cannot shoot that person. If I do that, so that will be beyond the reasonable. Okay, so that will not be reasonable. Okay, so reasonable force, okay, should be there, and the force should only and the force applied should be for only defense. Should be for defense only. Defense only. Should be for defense only. Okay. So this is a private defense. For example, like fixing a glass or spikes on the wall. As I have told you earlier, that this is a wall and like fixing glass, broken glass or spikes in order to prevent other person. So that will be, or keeping a dog, keeping a dog inside the house for his protection. So in such, so that cases are what? That is for the private defense. Okay. So now we'll move ahead with another general defense, that is mistake. So number 6 is mistake. Okay. So what mistake is? So generally, mistake of law or mistake of fact is no defense in the tortious liability. I really don't know why it is inside the general defense, but there is this condition in the book that I have read, that is, suppose, say for example, if I have committed certain wrong, okay, if I, intentionally or without intention, if I defame somebody, and if I defame somebody, I will be held liable for it, okay, because I have did it and I have violated the right of the other person. But so in such cases, I cannot say that it was happened because of the mistake and all that. I cannot take such plea. But there are certain situations where the mistake can be pleaded as a defense, okay, like where the conditions were required malice, okay. The situation where the malice is required. Say for example, malicious prosecution, malicious prosecution, that's it. So malicious prosecution, that's it, and all these cases, okay, in certain situations where malice is required. So in certain situations, you can take the defense of mistake. Okay, it is very simple. And so another general defense, that is necessity. Okay, necessity. So what is necessity? Okay, so necessity is that like when you done certain work, okay, certain act, and which causes the harm to the plaintiff, and you did it in order to prevent the greater evil, okay, greater wrong which is supposed to be happened. Say for example, okay, there is a sheep, okay, there is a boat, okay, I'm very bad at drawing. So this is a boat, okay, and there are many people are sitting and they are in and this is a creek, okay, and they are this boat is sailing over the river, okay, and during certain like calamities, what happened, the boat was supposed to sink, okay, it was about to sink, and because of the heavy weightage of the goods that is being carried out by the boat. Okay, so what the defendant does, that he threw away certain goods from the boat, okay, in order to decrease the weight of the boat. Okay, so he thrown away certain goods to the water. Okay, so here whatever the things is done by the defendant is for the necessity, because he is doing in order to prevent the greater evil. So greater evil is what? So there could be like, if he do not thrown out certain goods, heavy goods, so maybe the entire boat will sink, entire boat will drown in the river, and the many people will die. Okay, that will be the greater evil. So in order to prevent the greater evil, he has done certain things. He thrown away the goods into the water. So that is the act of the necessity. Okay, that is the act of the necessity, because the need of the hour of that moment. So the need is that to protect the person life. Life is very important. So protect the life of the person. So in order to protect the life of the person, he throws away certain goods of the particular person, many persons, with intention only. So in certain situations, the defendant will have the right to take the defense of necessity. Okay, it is very simple. Or say, take another example. Doing a surgery of an unconscious man in order to save his life. So that is also a necessity. Okay, if you do not, if the doctor do not, conduct the surgery, just because the person is not conscious and not capable enough to give the consent. So in that situation, whatever the steps taken by the doctor in order to save the life of the person, so that will be regarded as a necessity. Okay, so this is what the necessity is. So there is one case, okay, this Crick versus Gregory. Crick versus Gregory. What happened in this case? There was a lady who died. Okay, there was a lady who died, and what happened? The jewelry, all the jewelry of the lady, were removed from the place of death to the. And the defendant kept the jewelry in another place, in another room. Okay, and from there the jewelry was stolen. Okay, jewelry was stolen. And when the plaintiff filed the suit, and the representative of the deceased person filed the suit against the defendant that where is the jewelry? Then defendant said, it is like I kept the jewelry for safest custody in my room, and from there the jewelry was lost. Jewelry being lost, but now the court held that the defendant is responsible because it was not an act of the necessity. So the safe custody was not required because no one is going to steal from the dead body. Okay, so like that the court has said. So this is not the case of the necessity. Okay, so defendant was not allowed. So I hope it is clear to you. Necessity. So very small topic that you can easily understand. The only thing that is really important of general defense, that is act of the God and volenti non fit injuria. Okay, and the last general defense, that is statutory authority. Statutory authority. So it is a statutory authority. Remember that. Okay, it is a statutory, not statutory. Okay, I have heard many people saying statutory or statutory also. It's not statutory or it's not statutory. Okay, it's always statutory. Okay, statute. S-T-A-T-U-T-E. Statute. Okay, statute. Or S-T-A-T-U-E. So what is it? It's a statute, right? So it simply is a statutory. All right. So statutory authority. So what is statutory authority? So the statutory authority means the person who is authorized to do certain act by the government. Okay, statute. What is statute? Means act. Okay, act. Okay. Say for example, CRPC. Okay, CRPC is act. Okay, CRPC is act. So under the CRPC, police persons are authorized to arrest another person. Okay, he can arrest another person, but with the condition that if it is a cognizable offense, and then it's a cognizable offense, and there is a FIR being filed. FIR, in certain situations, like the police authority has the right to arrest the person, right? So in that case, the person cannot file a suit against the police for the detention and all that, because police was authorized and they are the statutory authority, okay, and they are doing their job, okay. So that is, in certain situation, the police authority, or say the person who is being authorized under the statute, will have the defense of the statutory authority. Okay, let's take another example. Suppose the government has enacted a legislation, okay, for the railway line, okay, okay, and the railway line, it should be from point A to the point B, okay. So in order to reach the point A and point B, there is a various land of the person, okay, private, there is a the land, private person. There is a between, from point A to point B, there is in between there is a private land occupied or owned by the private individual. So in that case, since the Parliament has enacted the legislation for the construction of the railway line, so now they have to construct the road, okay. They will not construct the road. So during the construction, these persons, or like whoever the person is there occupying the land, they cannot restrict the workers, because they are the statutory authority enacted by the government, okay, appointed by the government. So they are doing their job, okay, and while doing it, obviously the private individual will be provided compensation for it, okay. They cannot say no, we don't need compensation, we want this land. They cannot say it, okay. So that's what it means, okay. They will be provided proper compensation, whatever they will be competent for. So this is the statutory authority. So under the statute, if the person is authorized to do certain act, and that act becomes harmful to the other person, that person will not have the right to sue the defendant, okay, because the person is acting under the statute, okay. That's what it means. So yeah. So now this is the end of this video. I hope you enjoyed the video, and I hope you like this video, and I hope you find my effort a little helpful for you. And if you find somewhere that my video is helping you in any way, then do hit the like button and do subscribe to my channel and share this video with your friend. I'll be really glad if you do this. Thank you so much for watching this video, and this video has become a little lengthy. I'm sorry for that, but I'm helpless. I have to do it, since I have promised that within 12 videos I will cover law of tort. So I have to be, I have to keep up my word. So thank you for watching, and stay tuned. God bless you. Bye.